PB Elder Law are the only firm in Western New York that are dedicated to elder law, and we are here today to learn about trusts. Linda Grear is a partner at the firm.
A living trust is essentially a legal document that an attorney would prepare to hold on to assets for you. That trust can benefit you for the duration of your entire life, and after you die, it will distribute out to who you've named as your beneficiaries.
Are there different types of living trusts?
There are. So under the general umbrella of a living trust, there is a revocable and an irrevocable trust. So a revocable trust is as it sounds. It is revocable, amendable, you can change it, and it's really just an extension of you yourself. An irrevocable trust is the opposite. It is something that we create, we put assets in, and we cannot unilaterally change it on our own.
Can a living trust help avoid probate after death?
It can. So both types of trusts, revocable and irrevocable, can avoid probate. Both types of trusts will bypass having to go to a court proceeding, which is the probate process. Both trusts will allow you to establish controls for how your heirs will inherit, and you can put all of those controls in place. You nominate somebody that's going to manage the trust for you. That person's known as a trustee. The major difference between the two is protection from a nursing home. So a revocable trust, because it's an extension of you and uses your own social security number, is freely accessible by you, doesn't give you any protection for a nursing home. That's where we would actually be looking to an irrevocable type of trust.
So at what point would you want to, if you had a revocable trust, at what point would you want to make that become an irrevocable?
So whenever we're talking about protecting assets from sort of long-term care, we always have to worry about the fact that there is a 5-year look-back period. This 5-year look-back period that exists is essentially a period of time from the date that you apply for Medicaid and you look back. Medicaid's going to be looking to see if you gave away any of your assets. Essentially what they're looking to see is, did you have assets and then divest yourself of assets or give away assets so that you can become eligible for Medicaid. If you did it more than 5 years ago, they can't even ask you about it. But if you did it in that 5-year window, we do need to worry about the fact that they will impose a penalty, and we have to calculate what that is and plan appropriately for that. We want to try to do things, obviously we don't have a crystal ball, so we don't know when things are going to happen, but we want to try to always keep in mind that there's this 5-year period of time that we need to clear. So the sooner, as soon as you're maybe, I would say in your 70s, you're starting to experience some health issues or something's happening within your family circumstance that warrants a reconsideration of what you're doing, I would say that's when we want to start thinking about taking a revocable trust and making it irrevocable.
What are the next steps if someone's interested in finding out more?
Sure, absolutely. They can contact PB Elder Law, and we're at 716-204-1055. You can find us on the web at pbelderlaw.com.